SJC-12018, Karen Partanen v. Julie Gallagher.
Ms. Bonato, welcome back.
Kindly.
And when you're set, you may begin.
Okay. Good morning, Your Honors, and may it please the Court. I am Mary Bonato, and I'm here with Polly Crozier, Elizabeth Roberts, Teresa Harkins-Levita, representing Karen Partanen. The two children in this case, like all children, deserve equal consideration under the law, whatever the circumstances of their birth. The children here were born into a relationship where the parties mutually decided to create a family together, jointly consented to assisted reproduction, and then raised and cared for those children in every way throughout the years so they would know they had two parents and two sets of extended family. Both held out as parents, mommy and mama, not just to the children and each other, but the wider world. The plaintiff respectfully asked this court to ensure that non-marital children can have their parentage determined like others who were born through sexual reproduction and have the same security, protection, and support that flows from a legal parent-child relationship.
Let me ask you, do you need to have both Chapter 46, Section 4B and 209C construed the way that you're proposing? Or would it be enough to have Chapter 46, Section 4B construed the way you want?
Or 209C.
Or 209C? Do you need them both?
I don't think we need them both. I think both make sense here. 4B makes sense because there is a definite benefit, that is parentage, that is being provided to children born through assisted reproduction to married couples.
But, well, we can get there.
And likewise, with respect to 209C, the statute, with respect to the definition of child born out of wedlock, does not constrain the statute to children born through sexual reproduction. And these children, as the facts already demonstrate, were born to this couple. And so we believe the statute is broad enough. So it could be both, and it could be either. 209C would be a vehicle for assessing the best interests of the children, and once parentage is determined, deciding what support they're entitled to and what custody and visitation.
So how does this work? I was trying to understand how 209C Section 6 would work. You say because this couple held out, what is the word? Welcomed, welcomed the children into their home and openly held out the child as their child. That creates an irrebuttable presumption of parents. Is that what you're saying?
No, in part, Your Honor, it's not an irrebuttable presumption.
It's not irrebuttable. It's not rebuttable by genetics, though.
In this instance, it should not be rebuttable by genetics. And I say that because the cases that this court has decided have been premised on the idea of sexual reproduction, not assisted reproduction. And with sexual reproduction, if there's not a genetic relationship, then it is possible that there is another genetic progenitor out there who could be a putative parent. And that is not applicable here.
Okay, well, let's step back. And I mean, it seems to me that the statutes ought to treat heterosexual couples the same way they treat same-sex couples, both with respect to parenting and other issues. So, boyfriend, girlfriend, they've lived together for a couple of years. Girlfriend decides would like a child. Boyfriend is unable to produce. She is, therefore, artificial insemination, reproductive, as a child. Child is born. They're happy. They sort of hold this out as their child. A year later, boyfriend says, I'm out of here, and takes off, goes someplace else, goes out with someone else. He is presumed the parent of this child forever.
He is presumed the parent because part of what...
And he cannot be rebutted.
Well, with respect to, let me just bracket rebuttal for a moment, Your Honor. But with respect to presumed a parent, yes, he is presumed a parent because by consenting to assisted reproduction, just like participating in a sexual act that may result in the conception of a child, that is procreative activity, and our statutes say that people are responsible for their procreative activity. 209C is there as a backstop for all children, no matter how conceived in our view.
Well, what about the mother here? I have this child, it's a 1-year-old child. Okay, we held the child out for a year as ours, but what
Yes,
about
and then,
her?
yes, okay, oh, I still want to bracket rebuttal for a moment, but what happens at that point is,
I don't
assuming,
want this fellow who was my boyfriend during the period of time when I decided to go through this procedure to be the child's parent. The child's going to grow up for another 50 years.
well, as Your Honor pointed out, in custody of Cali, there are circumstances in 209C and in Section 10 that bear on the best interests of a child born to an unmarried couple.
So one could, in this case, assuming the young man goes into court and says, I want to be the parent, I want to be legally the parent. He's not on the birth certificate, hasn't pursued an adoption, but just goes into court. I was with her when child was born. I want to be designated legal parent. At that point, mother can say it's not in the best interest of this child, therefore that's the reason why he can't be the legal parent?
Now, there's actually a predicate reason, if I may, which is with
Okay.
respect to the scope of the statute itself. And we read Chapter 209C, Section 1, the third sentence, the definition of child born out of wedlock, to apply to children who were born to, as the statute says, an unmarried man and woman, which we believe has to be construed as in a gender-neutral fashion here. And so born to provides an inherent limitation. And so if, for example, somebody comes in later, as, for example, this court's case in CM, or in RD for that matter, when you have a later person coming in who was not part of the decision to bring the child into the world, there's certainly an argument that that child was not born to that couple and is not a child born out of wedlock within the meaning of that statute. And so if, by contrast, as here, where the record facts demonstrate that there was assisted reproduction, first with Partanen attempting pregnancy and then Gallagher, and that they succeeded in this and they jointly raised those children in their home.
Well, the second child they raised for a little over a year before your client left.
And they have continued
So
to...
it's not like raise the child up from nothing to a teenager. It's just for a very short period of time.
Although, Your Honor, just to be clear, they have continued to co-parent together since that time.
By order of the court or?
By order of a court in another action,
And
yes.
I mean, the de facto parenting was an agreed upon resolution of that issue, was it not?
Yes, that is outside the record of this case, but it is in the addendum that the parties, when they went to trial on this, did stipulate that Partanen met the qualifications as a de facto parent. And in that stipulation, as well as in the defendant's brief in this case, there are concessions, although they're phrased somewhat argumentatively, about agreeing to hold out as a family while they were together, acquiescing to Partanen, accepting Partanen's acquiescence in the insemination, the children having an emotional relationship. And that addendum, by the way, in the addendum, there's also a stipulation that the children could be harmed by disrupting the relationship that already exists between Partanen and the children.
At what point in time could your client have filed a petition under Chapter 209C? Could it have been the day of birth or the day after birth, with a year after birth? How does that work out?
Well, the parties were living in Florida until sometime in 2012, at which point they relocated here and the relationship dissolved. And I'm not sure I should depart from the record in the case.
Okay, but if the child were born here, and the decision, if all the decisions that were involved had occurred here in Massachusetts, could your client have filed a petition under 209C the day of the birth or the day after the birth?
Well, with respect to holding out focuses on post-birth conduct.
So
And
for how long?
Well, there's not a durational limitation set forth in the statute, so we'll wait the court's guidance on that. But in any event, these people did hold out. They brought the child home and held out.
But under 4B, there isn't it goes from birth, right?
Yes, and that is a significant difference, which is that under 4B, there is protection for the children conceived this way from
So could I
birth.
pursue Justice Cordy's example further, because I want to understand if, in his instance, it's not that the boyfriend is the biological father, it's that there was IVF or some form of artificial insemination that took place to which he consented. So from the time of the child's birth, he, in that example, would be the legal parent, notwithstanding what the woman who bore the child may feel toward his ability to be a good parent or anything like that. If he consented to that procedure and the child was born as a result of that, he is that child's legal parent under your construction of 4B.
That is correct, as long as there is mutual consent.
I understand.
Let me ask you that about 4B, though. But let's assume that your interpretation of 209C is accepted. So there is a way for a person in your client's position to establish that she is the legal parent. But under 4B by itself, given the fact that men and women can marry any way they want, couldn't the legislature make a judgment that, in fact, marriage is a good thing for a variety of reasons for the children as well as the couple? I mean, there's a letter in the New York Times today talking about the value of married couples to the development of children. So, I mean, in other words, the fact of being married, I totally appreciate that the statute shouldn't be I mean, you can read husband with gender neutrality. But marriage as an institution seems to me something that perhaps the legislature has the right to say, we think this is important.
That raises, Your Honor, another issue, which is, as much as the legislature can certainly rightly assume that marriage is a beneficial institution, this case raises the question about the rights of the children, and not...
But does 4B do that?
Well, I believe so, Your Honor, because of this court's consistent rule that the same rules have to be, and protections have to be extended to non-marital children. What happens is if 4B were to carry the day...
Isn't that what 209C is about?
Well, that's why I'm suggesting both, Your Honor, that I think 4B certainly applies here under our construction, which is the same benefits have to be made available to non-marital children, because what's being established is not a marriage between the parties, but a parent-child relationship, and the stability and certainty that come from that, the benefits that come to the child through a legal dependent relationship, again, upon birth, as this court discussed in Culleton.
To a legal dependent, marriage is the vehicle. How can 4B be read any other way? You're saying, well, 4B creates a right in the child to have two parents? Is that what 4B does? It doesn't say that.
4B, at least according to O'Callagher, decided by the appeals court, when there's consent to assisted reproduction, then there's protection for the parents. They are denominated the parents upon birth, and protection for the child from having those parents immediately upon birth. And that
Doesn't
is,
marriage provide a degree of legal protection that 4B might anticipate? You know, if the child is born to a married couple, there are certain support obligations and so forth that simply flow. It's all statutorily spelled out. The authority of the probate courts to adjudicate situations that result from the dissolution of the marriage. It's all sort of taken care of in a way that's a little bit different when you have unmarried couples.
and that's where, again, we would argue that the policy in 4B should be applied in 209C, because 209C is then the vehicle for assessing, in this instance, what are the child's best interests. The child deserves, under law, a declaration of her parentage, his parentage, and likewise then an assessment about support from the parent, as well as what custody and visitation is appropriate. And again,
That if it's a legal parent under 4B.
that's correct. Although, well, I'm sorry, could you repeat that, Your Honor?
I said, do you really need that if you have, if unmarried parents the unmarried parent who consented to the procedure is a legal parent from the time of birth? What do you need 209C for? What does
Well,
it add?
Well, what it adds is a vehicle for assessing rights and responsibilities immediately. And again, the Attorney General mentioned in her brief, and we addressed it in our reply brief, that one of the issues here is that the voluntary acknowledgement of parentage is not currently available to same-sex couples. I mean, they're immediately screened out because everyone knows they don't both have a genetic connection to the child. And
You mean on 209C?
correct, yes. And that would provide protection upon birth as well. So perhaps another way of thinking about this is if it's important to provide immediate protection on birth, a voluntary acknowledgement will not help my client, but it would help other people. And that is why we also want to continue to pursue the issue of holding out. Since again, these parties have jointly raised these children understand both of these women to be their parents.
What does it mean to openly hold out the child as their child? In the traditional context, it would mean you would say that, you know, in a heterosexual relationship, that I'm the father. In a gay relationship, you would say, if it's enough to say she did ART, do you have to openly say that we did ART?
I don't know that you need to openly say we did ART, but what these people did was everything that they believed at the time that they could do, which is tell everybody in their immediate circle and the wider community, the schools, the doctors, that they were both parents, executed a certain number of authorizations for medical care, had some reciprocal other documents. So they did things to say we are the child's parents and refer to each other as the parents
So
when
that
they
may,
interacted.
that may help you here. What if there's acquiescence? What if you have somebody in which the record suggests that she really wanted to have a child? We were living together. I said, fine, I will do what I will be the dad, but this is really her idea, not mine.
Yeah, I agree that this case is not going to be the model for all other cases. And I can imagine that in future cases, depending on how this court construes born to, that there may be disputes about whether a child was truly born to a couple and whether they held out.
So, but you focus on mutual consent as being required. You can, it must be mutual consent, not just acquiescence.
Well, with respect to mutual consent, let me just say this. I mean, we believe that in the facts of this case, there is that mutual consent. It's about as clear a proxy for biology as you could get, and that they, in fact, held out. There would, I think, easily be, if you look at holding out, the text of the holding out provision, it doesn't require intent to,
So you say we just don't have to reach that question because we clearly have it here.
yes.
But I'm trying to then go back to what Justice Cordy said. You agree this is a rebuttable presumption. And how would you rebut it?
You would rebut on facts about whether or not the child was born to them or not. So, for example, you
Well,
could
I
have
mean,
a
you
woman
could-
who,
Okay,
sorry.
I mean, let's assume there's no dispute that indeed she was born as a result of ART. The dispute would be, did the other partner consent? Does the absence of consent rebut the presumption?
For holding out,
Yes.
it may in some circumstances, but holding out itself does not require consent to assisted reproduction, I guess is really my point here. So it may be that somebody did use assisted reproduction on her own. She felt like her biological clock was running out. And the question will be, was him being around for this, consent so that you have born to, or did he really have nothing to do with it and she did this on her own? So the child really wasn't, quote unquote, born to them, and then it's more like some of the other cases this court has decided. And there's also the question about holding out as your own. And, the court will have to construe that term. It's been construed by other courts, and we mentioned some of those in our brief, as do some of the amici briefs. But a lot of that has been both parties undertaking responsibility for the children, the kinds of factors that you see, for example, in 209C, Section 10A.
Okay, but I'm still struggling. It's a rebuttable presumption, and you say it may be rebutted only by showing the absence of ART or the absence of the mother truly being the mother, and not rebutted by proof that there was not mutual consent?
I'm going to make sure I'm getting this right, Your Honor, because I agree
Just
it's
trying
an
to sort. I
important
mean,
point.
you want us to apply 209C, Section 6 subsection A4, which is the holding out provision. You agree it is a rebuttable presumption, and I'm asking you in this circumstance, what proof would demonstrate that it is rebutted?
Okay, turning to the statute itself in 209C Section 1 in that third sentence, there would be a question about whether or not they had engaged in enough mutual activity, whatever it may be, in decision-making to say the child was born to them. And then secondly, there'd be questions about holding out. Had they held out sufficiently? In a case like this, in Partanen's case, there really is no dispute about there being some other party, and as the defendant concedes, the biological facts are indisputable, which is why, again, we ask the court here to reverse the trial court, and in light of the additional proceedings and the concessions made already in the defendant's brief, to remand for determination of parentage.
Okay.
Thank you, Your Honor.
Good morning. May it please the court, I am Jennifer Lamanna, and I represent Julie Gallagher. The full panoply of parental rights is not available without deliberate legal action. De facto parenting amply protects the emotional bonds that are formed by the holding out relationship.
What, can I just ask a practical question? Given the agreement of your client that the de facto parenting relationship has been established, what is the fight about? I mean, what's the legal parent, why is that such a big issue in this case?
Because what's at issue here is my client's legal custody of her children, her right to make medical decisions, religious decisions, educational decisions.
And the de facto
free from
parenting
interference.
status doesn't give Ms. Partanen any opportunity to
It has
participate in
not
that?
before. It has not before. This court has consistently held that. In AH versus MP, this court said, we decline to erase the distinctions between biological and adopted parents on the one hand and de facto parents on the other. And the court has also addressed this in ENO versus LMM, where it says, look, the de facto parent doctrine is an acknowledgement that bonds are formed in non-traditional families and that the person who stands there as the bio mom, the natural mother, cannot sever those bonds at will if severing those bonds will cause harm to the children. It acknowledges the fact that the non-traditional family structure can result in bonds between children and these other caregivers that need to be preserved. However, what's at issue here is my client's legal rights as the only mother. What Partanen seeks in this case is a path to parenthood that doesn't require marriage, doesn't require adoption, doesn't require a signed voluntary acknowledgement of parentage, and in fact can be imposed without the consent of a parent and over the objection of a fit parent. And that is
Would you
where we part
agree
ways.
If these children had been born here as opposed to Florida, could your client and Ms. Partanen have signed a voluntary acknowledgement of parentage?
I believe that they could. That I think 209C, I think it has to be read as gender neutral, and it has to be read to permit the establishment of paternity in the same ways that it's practicable to establish paternity, and that's what Section 21 of 209C specifically says. To all extents, you may use this statute to establish maternity the same way as far as it is practicable. So then you look at Section 11 of 209C. Section 11 of 209C says that the parties may sign a voluntary acknowledgement of parentage. The form, there is a form promulgated specifically for that, but the statute does not require that that form be used.
But I gather that the form would need to be changed, because right now, you could not sign this form unless you truly were the father.
If you use the form, but there's no requirement under the statute that you use the specific form. If, for example, you were to create your own form and you were to find yourself stymied by the Registry of Vital Statistics, you could then, because you had the consent of the biological mother, go to court, file a parentage complaint under 209C, and offer to the court a judgment.
Are you speaking
By agreement.
hypothetically, or is this something that is actually happening? people using their own forms in these circumstances.
I can say that the forms that are being issued in Middlesex County right now have a number of errors. It actually says mother in both signature sections. So I think technically both the parties themselves could have signed this in Middlesex County.
But I
right now.
mean, that doesn't bear here. You're not saying that because in Florida she did not create her own form in Florida, hoping that Florida would accept it, that has consequence here.
No, I'm not suggesting, what I am suggesting is, first of all, Florida has a different set of rules, and these children were born in Florida, and as I do argue in my brief, I think that this court is required to look to Florida law and see what was available to the parties in the state where they chose to have their children. That is, if the court accepts the idea that there has been mutual consent to the ART, which is an issue that we certainly dispute. But focusing just on what Florida law requires. In the reply brief, Partanen attaches a Florida form. I don't know if that's the form that was available to the parties at the time. I don't know if it's the current form, but I do know that here in Massachusetts, there is no time limit. I think one of the justices was asking about that. When could the 209C procedure be followed? There is no time limit. There's no requirement that it be done within a certain time frame. It can be done later. It could have been done the day they arrived in Massachusetts. I would submit to this court that a valid reading of 209C would have permitted these parties with mutual consent to appear before a probate court and submit a voluntary acknowledgement of
Let
parentage.
me ask you a question about, it's counterfactual, but could your client have sought support orders against Partanen?
I would say that this court's holding in TF versus BL says no, because that's exactly what was going on in that case. You had two people who, there was an allegation of consent to ART, and you had, in that case, the non-birth person was saying, I didn't consent enough that I should have a child support obligation against me. And this court held that parenthood by contract is not the law in Massachusetts. So I would say my client could not have gone into court absent Partanen's consent and sought a child support order against her, and that would have been because this court's holding in TF versus BL would have prevented it.
What in 209C, in the sections that Partanen is relying on, where is the biological requirement?
Well, in the sections that she's relying on, there isn't one. So, much of the reliance is placed on that holding out language in section 6A4. And this court already addressed the significance of that language in the CM versus PR case. And in CM versus PR, you had someone very similar to Justice Cordy's example. You had a father, a presumed father, coming forward seeking to establish his legal parentage. And he pointed out to this court, I would be required to be joined under any paternity action under 6A4. And the court said that's irrelevant. It's a joinder provision. You are admittedly not the father. So that joinder provision has to be read in conjunction.
What about Cheryl?
So I think the holding of paternity of Cheryl has been stretched well beyond its boundaries at this point. So as I read paternity of Cheryl, it's a situation where fundamentally the court's holding was, sir, you signed a voluntary acknowledgement of parentage. You agreed to a judgment of parentage. That judgment became law, the law of your case. He did not seek genetic testing, although it was available to him under the statute. He chose to forego genetic testing.
There's a great deal of language in that case about the importance of the child and sort of superseding whatever traditional rights he might have had as not being the biological father, right?
There is a very helpful, I would refer to it as dicta, but there is a very helpful discussion in paternity of Cheryl about the fact that there comes a certain point where bonds have been formed and the court will not undo them.
And a judgment has been entered, and this is such a different case.
It's such a different case. Judgment, I think that's the real holding of paternity of Cheryl. You will not be heard to complain about your lack of genetic relationship to a child 11 years after you signed a judgment and you signed a voluntary acknowledgement of paternity.
If I can go back to Justice Cordy's example,
Yes.
which is the heterosexual example, if that male is capable of producing live sperm and is the donor through sexual intercourse, he's the father no matter how he feels about it.
That is correct.
if that same individual is unable to help inseminate a child because of some biological issue, and consents to somebody else providing the sperm, and says, I wish to have a baby with you, and I will essentially mutually consent and cause another person's sperm to be inseminated, why is it different?
It's different because the legislature says that it's different, and the legislature has already established procedures for establishing your parenthood under those circumstances. Adoption is specifically for that context. If a woman chooses to be inseminated with sperm other than that of the male that she's involved with, for whatever reason, adoption is available. The voluntary acknowledgement of parentage is still available. Marriage is still available. So the issue, what makes it different, is that when you have not engaged in the old-fashioned way of creating a child, which is intercourse between two people, and everybody understands that the mere act of engaging in intercourse could result in the birth of a child, so you cannot be heard to say, that was not my intention later. If you intended the act of intercourse and a child results, you are the legal parent of that child, on both ends, the mother and the father.
The sperm donor is not the father.
That is correct. That is correct. And this court has consistently held that.
Right.
A identified sperm donor is not a legal parent.
Were you done? Well, if 209C's purpose is to make sure that children who are not born of a married couple are treated the same as children who are, for a whole variety of reasons, I'm still lost on why the biology matters so much to you. When it is,
Okay.
well,
I'm sorry, were you-
when it really
Yes.
isn't explicitly in play in the statute.
Because I think it is in play in the statute in a number of different circumstances. First of all, the only way that you can rescind your voluntary acknowledgement of paternity is it says the court shall order genetic testing. So if somebody signs that voluntary acknowledgement of parentage and then chooses within the correct time frame to undo that voluntary acknowledgement, the court shall order genetic testing. And if you are determined to have a biological connection, you cannot walk away.
So the availability, I take it, what you're saying, the availability of genetic testing to establish essentially an irrebuttable defense to paternity is implicit in it is implicit in the statute that there be a biological connection between both parents.
Again, without consent of both parents. So I believe the statute is amply able, with the language that is currently there, to allow consenting adults to establish parenthood absent a biological connection.
So
But
the mother in this situation always holds the key in her hand, the biological mother. She can do everything, and the other parent is there, and then she can say, I'm not going to consent, just when you need it, or I've changed my mind.
I think that's something that
That's what we've enacted?
I think that adults have the ability to form legal relationships, and they can be made aware at a very early time as to whether or not the legal relationship they seek with someone else's biological children is available to them. Just as you would not hear from someone standing before you saying, I was willing to get married. He didn't want to get married, but we held ourselves out as husband and wife. I was always willing to take that step, and then when he decided to end it, I had no property rights. You would say, as this court has consistently said, that people have the right to form certain contractual relationships. If they choose not to form them, then they cannot come to the court to seek those same rights.
What about the rights of the children as opposed to the rights of the adults? I think that, what was striking about both briefs was that the difference in perspective, one from the child's perspective, one from the adult's perspective. You've said that the de facto relationship is different from the legal parentage relationship, that your client would not have been able to get support from Ms. Partanen. So from the child's perspective, even if Ms. Partanen is the de facto parent, you couldn't force upon her the obligation to pay support. So from the child's perspective, just on a purely financial basis, that's disadvantageous to have only one person on the hook financially as opposed to two.
It may be disadvantageous, but
So-
it is not illegal. and
Well,
it
I didn't
is-
say illegal, but I'm saying in terms of a policy construction of 209C and/or 4B, don't you think that it is more advantageous for the child to be able, if born out of wedlock, to be able to have support obligations on two people?
It may be, it may not be. There are plenty of children out there who have two parents to support them, and we have long lists of people who aren't paying their child support.
No,
So
it's
the
not
mere
just
fact
child
that there are
support. I mean,
two-
that was, of course, one, but I mean, in the event that the one parent is ailing or dies, you have another parent.
We have an entire set of statutes in Massachusetts which secures a single woman's right to become pregnant and raise that child by herself. It is
So her right should take priority over the best interest of the child?
her right to decide what legal framework she gives birth to a child to trumps a child's desire. I firmly reject the suggestion that in Massachusetts, we've established a child's right to have two parents. A child does not have a right to have two parents. A child has the parents that they are born with. In this particular case, these two children were born to a single woman who chose not to marry and who chose not to undertake the
another
legal
woman.
bonds.
Who was living
She
with
was in a
another woman
relationship
as
with another woman.
in a
That is
committed
correct.
relationship?
That is correct that she was in that relationship. And it is correct, absolutely, that by being in that relationship, she allowed her children to form emotional bonds which she cannot sever
Hold them out
arbitrarily.
as her children. She held them out as their children, did she
Well,
not?
obviously, this is at the motion to dismiss stage, so utilizing the facts alleged. But how far did that holding out go? Did it extend to giving the children Partanen's last name or any hybrid of it? No, it did not. Did it extend to putting Partanen's name on the birth certificate? No, it did not. It did not extend to
Not
the
even clear
parties
that that could have
themselves.
happened, is it?
Pardon me?
It's not even clear that that could have happened in Florida at the time, is it?
It wasn't even attempted.
Well,
And she
Well-
certainly, and you can give your children whatever, she could have given Partanen's name as a middle name if she wanted to
those
identify
are
her on their
hardly
birth certificates.
earth-shattering criteria.
I'm not suggesting they're earth-shattering. I'm saying, but that they are clearly the acts of volitional adults. These are and our courts have consistently held this, that where people have exercised their rights to forego legal connections or to form them.
And
this court
somehow
is
the
not going to
child is
assume
held
them.
hostage to that? That
I
just
don't think the child's being held hostage. I think the de facto doctrine amply protects the emotional bonds that are
Except
formed.
there's no, you've made it really clear that you feel that there is no obligation on that de facto parent to provide anything by way of support or,
I'm not saying, I'm not, that's not what I suggested, Your Honor. What I
Well, I
suggested
asked
was
you if
that
your
this
client
court's
could
current,
have-
the state of the current law
Well-
is that you have not, this court
under
rejected
the
that
state of the
premise.
current law, a de facto parent has no support obligations.
Under this court's ruling in TFVBL, that's correct, that they do
And a
not.
legal parent does.
A legal parent does, yes. And that's a relationship that is formed by consent. There is no other avenue, there is no other area of law in Massachusetts where a legal parent loses their rights to make determinations regarding those legal custody issues we discussed, absent a showing of unfitness. And the relationship that was formed here between the children and Partanen is amply protected already by this court's common law de facto doctrine.
I think you said at the beginning that the sperm donor has no rights at all here, right?
This court has held that, that's
Okay,
correct.
so we have these, so there's this class of children who, from conception on, have one parent. I mean, that's biologically impossible, and it seems to me it's socially very ill-advised.
We allow single parents to
Like I
adopt.
say, we have a lot of single parents out
We
there.
have a lot of single parents
Allow
for a
that.
lot of circumstances, but I think legally there is another parent that's around. And you're
Legal-
saying that legally there is no other parent.
Actually, there is, legally, there is not. She's not a biological parent, and she didn't take any of the steps that the legislature has already established as a path to legal parenthood. I would point out, I noted in my brief, but if I can just reference this, it is, I think, inherently absurd to suggest that we, in a state where it is forbidden for an insurance carrier to deny coverage for artificial insemination to a person based on their marital status, to then claim we have this overarching policy that children are entitled to two parents. It is absurd to suggest we allow single adoption, but say we still have this overarching policy that someone have two parents. People are free to form associations, both factual in the de facto context and legal in the adoption, marital, and the VAP context. And if they choose not to do that, where the statute has already prepared that avenue, it should not be enforced upon them.
Just one last question. Judge Casey's order has nothing to do with this appeal, correct?
Correct.
Is that being appealed, or is that?
Yes, it is.
So that's being separately appealed?
That is
So
correct.
that is, there is nothing of that that is presently before us?
That is correct.
Okay.
Thank you.
We'll take our morning break.